China very importantly said that people in defending their right to self-determination can use armed struggle. Pakistan also made a strong case for Palestine, arguing that Israel cannot benefit from a wrong of its own making, as well as other states with it also asked the ICJ to reconsider the permanent 5 members of the Security Council's use of the veto. We have come to an end of 6 days of public hearings on the topic of the legality of Israel's occupation, annexation, settlements, and racial discriminatory practices before the International Court of Justice. Now, states made some very interesting legal arguments before the court. Some argue that Israel's occupation and settlements were unlawful, and its racial discriminatory practices amounted to apartheid. Others, such as Canada, Italy, the UK, Zambia, and Hungary, argue that the court should not take the question at all, as advisory opinions can be accepted on a discretionary basis. This is based on the provision of the ICJ statute, which says that the court may give an advisory opinion on any legal question sent to it. Now, these states argue that the court should exercise its discretion here and decline to give an advisory opinion on the basis that this is essentially a political question. This is quite a weak legal argument, and the court has not in over 100 years accepted this. The last time it did so was in 1923. The second prong of this argument is the fact that they say Israel has not consented to these proceedings, and so it would be unwise for the ICJ to go ahead and give an advisory opinion. Now, again, this is quite a weak legal argument. The court, in its Chagos Islands advisory opinion, ignored the fact that the UK had not consented to those proceedings. Similarly, in its Western Sahara advisory opinion, it also ignored the fact that Spain had not consented to those proceedings either. In terms of other states and their arguments, China very importantly said that people in defending their right to self-determination can use armed struggle. They were the only state, however, to make this argument before the court, to the criticism, of course, of Israel. Guyana also, in an important contribution, said that in terms of political resolution, no negotiations have been ongoing for over a decade now. So in terms of the court's advisory opinions stymieing a political resolution, in fact, it will be able to help that. The United Arab Emirates, in the first time that it was ever appearing before the ICJ, as well as other states with it, also asked the ICJ to reconsider the permanent 5 members of the Security Council's use of the veto in coming to an advisory opinion, especially when serious breaches of international law are occurring. Pakistan also made a strong case for Palestine, arguing that Israel cannot benefit from a wrong of its own making. We also looked at the fact that there were many more French settlements in Algeria which were dismantled and withdrawn than we see in occupied Palestinian territory, showing that practically it is possible to remove these settlements. Pakistan's team also looked at the fact that the holy city of Jerusalem was traditionally and historically one where all faiths could practice together. And even an Ottoman decree from the 19th century allowed Christians, Muslims, and Jews to come together and pray in Jerusalem. And this is something that Israel has been denying to Christians and Muslims. We will likely see an advisory opinion in the next 4 to 6 months. In the words of one state, this is a litmus test not only for our collective consciousness, but also of international law. And while we wait and see what the ICJ orders in South Africa versus Israel, it is likely that the advisory opinion will be one based on the precedent that the ICJ has already set in the Namibia advisory opinion, where it ordered that South Africa withdraw from that territory and that all other states work to bring to an end South Africa's administration of Namibia, something referenced in Namibia's statements to the court. Also, we had the Wall advisory opinion in 2004, so 20 years ago, the ICJ ordered that Israel dismantle that wall. Now, of course, Israel has not done that. It continues to be in breach of that ICJ ruling, which engages its state responsibility. Similarly now, Israel was due to report to the court on South Africa's provisional measures case under the Genocide Convention, which it did so this week. That has not been shared publicly by the International Court of Justice. However, Human Rights Watch has said that Israel is not complying with at least one of the binding measures ordered by the court, that of allowing in humanitarian aid, with its Israel and Palestine director, Umar Shaker, saying that the Israeli government has simply ignored the court's ruling and has in some ways even intensified its repression, including further blocking life-saving aid. So, to quote Palestine's representative, none of us is starry-eyed about international law, but it is what we have. So, with this violation of the ICJ's provisional order, with Israel's ongoing violation of its role advisory opinion, we remain non-starry-eyed yet hopeful.